Morning, Mr. Hitchcock. How are you?
Morning.
Mr. Palmer is here. Do you need a breakout room with him?
Yeah, could you do that?
You bet. Mr. Palmer, you're going to see an invitation to join a breakout room. If you would just click on that, please.
Hold on, please. Breakout room, breakout. I'm trying to see where the breakout room is located. Oh.
Mr. DiCarlo, can you hear me?
Yes, I can.
Hi, what case are you here for this morning?
Vision restoration versus Bales.
I'm sorry, I can't hear you.
Oh, hang on. Can you hear me now?
Yes, I can.
Okay, there we go. Yeah, vision restoration versus Bales.
Oh, okay. Are you the attorney representing?
Vision restoration.
Okay, thank you.
Mary Ann?
Yes.
Hi, Steve Hitchcock.
Hi.
I have a settlement with Mr. Palmer on this. So do we need to put it on the record or can we just, all
Yes, you do. Yep. I'll let the judge know.
right, great.
Good morning, ma'am. The person is identified as credit by Benita. Can you hear me?
This is 232536 GC. This is Calvertus Palmer versus Romulus Housing Commission. May I have your appearances, please?
Good
Yes.
morning,
Good morning, Judge.
good morning, I'm Steve Hitchcock, appearing on behalf of the Romulus Housing Commission.
I'm sorry, Mr. Palmer, state your name for the record for me, please, sir.
Calvertus Palmer.
Thank you. Today is the day and time set for the adjourned pretrial in this matter. Mr. Hitchcock, I've been advised that there's a resolution of this matter.
Yes, the Housing Commission has agreed to pay Mr. Palmer $1,000 on his claim and to reimburse him the $74.50 in filing fee and service costs that he had for a total of $1,074.50. And he will agree to sign a release of the Housing Commission from any further claims with regards to damage to his home on the date in question. And we'll dismiss.
And when will that be paid to Mr. Palmer?
It can be paid simultaneously with his signing of the release.
Mr. Palmer, were you able to hear Mr. Hitchcock just now?
Yes, ma'am.
And that's your understanding and agreement?
That is correct, Your Honor.
Thank you. Mr. Palmer and Mr. Hitchcock, what this court will do is adjourn this matter over to September the 5th at 9:15 a.m. If you are able to get your documents prepared, your releases signed, your payment made, whatever it is that you're doing to resolve this matter, if it's done before September the 5th, you do not need to appear. The court will accept your executed either conditional dismissal, stipulated order, otherwise resolving the matter.
Okay.
Understood, Mr. Palmer?
Yes, Your Honor.
Anything else, Mr. Hitchcock?
Nothing further. Thank you, Judge.
Thank you. You both have a wonderful day. Thank you for working things out.
And same to you.
Thank you.
Bye.
This is 220143 GC Vision Restoration versus Bales and Bales. May I have your appearances, please?
Good morning, Your Honor. Tom DiCarlo on behalf of Planet Vision Restoration.
Good morning, Your Honor. Jeremy Kennedy on behalf of Wayne Bales.
Thank you. Today is the day and time set for hearing on the motion to file the second amended complaint. Have the parties had the opportunity to speak this morning?
No, I didn't know Mr. DiCarlo was here on behalf of Mr. Bigelman.
Do you need to go into a breakout room?
Well, Judge, I don't have an objection to the motion. We have filed a complaint in circuit court on this matter. So I would ask that this case be joined with that one. But other than that, I have no real objection to his motion for that very matter or reason.
I guess the concern of the court is that we're scheduled for an in-person bench trial on August the 9th. At 1 p.m. So that's my concern, an amended complaint, a request to remove this case and join it with the circuit court case. If that's a conversation that you and Mr. DiCarlo want to have this morning, otherwise the court will rule on the motion.
Then maybe if we could have a couple minutes to talk, Your Honor.
Absolutely. Mary Ann will put you into a breakout room to discuss both today's motion, the August 9th trial, the request to join this case consolidated with the circuit court case. I'll see you in a few moments. Thank you.
Thank you, Your Honor.
So the gentleman that joined with the white T-shirt on, the goatee, your name, please, sir?
Michael McIntarfer.
Thank you, sir. Your case is scheduled at 9:30. We'll get you connected with plaintiff's attorney when they log on.
Okay.
Mr. DiCarlo and Mr. Kennedy? Have
Yes,
you
Your
not
Honor.
received an invitation to go into a breakout room?
I have not, Your Honor.
I'll send you one myself. Oh, there's
Just received
room
it.
5, please. Thank you. Good morning, Mr. Beach.
Good morning, Your Honor. How are you today?
I am wonderful, sir. How are you?
I am fantastic.
I have not seen Miss Taylor yet.
Yeah, Your Honor, I suspect she may be a no-show. She contacted our office and we worked out terms of consent judgment, which we have mailed to her for signature. So I don't know if the court would be willing to just push this over a few weeks. So hopefully she can get that back to us and we can get it filed.
Based on her answer, Mr. Beach, that's what I thought the likely outcome would be, but my policy is 15 minutes after the scheduled time. So if she's not here by 9:15-ish, I'll call your case and make note of what the proposed consent is and put it over to the September 5th date, but just sit tight for a little bit longer, okay?
That's fine. Thank you.
Thank you. Mr. Brown, I have not seen Mr. Collis yet this morning. Your case is scheduled at 9:30, but sit tight, please, sir. When he gets here, we'll get you connected with him. Ms. Hildreth, same thing. Your case is scheduled at 9 o'clock. I have not seen plaintiff's attorney as of yet. My policy is 15 minutes after the scheduled start time. So at about 9:15, I'll call your case, okay?
Thank you.
You're welcome.
Who coats the picture of that? That's just a Michael. Just trying to find something to sit on.
Mr. Kennedy and Mr. DeCarlo, we're back on the record in 220143. You've had an opportunity to speak. How are we proceeding this morning?
Your Honor, I don't think there's any argument about approving the amendment that we filed. And I'd suggested to Mr. Kennedy that given the amendment doesn't really change anything, I don't know that it's necessary to file an answer to it. There's no new allegations. He and I did have a chance to speak about the main case or the main issues, and I will speak to Mr. Bigelman in my office this afternoon to see if we can move forward towards either hopefully a resolution or to dealing with the request to transfer the matter to circuit court. But that's not something within my ability to discuss this morning.
Mr. Kennedy?
Judge, that is the substance. Again, we don't necessarily object to the amendment because I simply think that if there's going to be an amendment, then the case should be, removed from here and joined with the circuit court case to consolidate the issues. We are working towards trying to get some money to settle this case from the insurance proceeds but we have to get the repairs to a certain point before the bank will agree to release additional funds. We have a contractor that's doing work right now. So I'm hopeful that we can do that. And that's, I guess, kind of the unofficial reason to do that as well. But in general, like I said, our position is we don't have an objection to the amendment, but we would request that the matter be transferred to the circuit court and join in that case. And I
Have you filed
understand Mr. DeCarlo.
Are you and Mr. DeCarlo or Mr. Bigelman stipulating to that? Or is that something that the parties will agree to in writing prior to this August 9th trial date?
Mr. DeCarlo needs to speak to Mr. Bigelman about that, as I understand it, but it is my hope that the parties will stipulate to that and send the court an order in writing.
Your Honor,
For our purposes, I'm sorry, Mr. DeCarlo, go ahead.
I was going to say, Your Honor, at this point in time, our intention is to proceed with the trial that's set for next week. If between now and then something can be worked out, we will certainly inform the court in a timely manner. But that's where the case sits right now.
That being the case, the court will grant the plaintiff's motion to amend the complaint again, and barring receipt of some stipulated order from the parties, I expect to see you here in courtroom number 1, August 9th at 1 p.m. Anything else, Mr. DeCarlo?
Nothing further, Your Honor. Thank you very much.
Anything else, Mr. Kennedy?
No, Your Honor. Thank you.
Thank you. You both have a great day.
Thank you.
Bye.
The court has received notice that there was a few court notices that have the wrong Zoom ID on it. I went down and had the other courtroom log on, so people are being directed here. So there will be a delay in having some of the matters called, but please sit patiently. Mr. Cox, I believe that you were with Ms. Hildreth.
Yes, Your Honor.
Well, I'll get you into a breakout room. Ms. Hildreth, you'll see an invitation to go into a breakout room with Mr. Cox. Please go there. Speak to him about the case. When you come out, I'll get this matter called, okay?
Thank you.
You're welcome. Mr. Drosky, do I need to get you connected with Ms. Lacy to discuss the Jenkins Easley matter?
Yes, that'd be helpful. Thank you.
Let's get you into a breakout room.
Okay, thank you.
Thank you. This is 232745 GC Credit Acceptance versus Taylor. Your appearance, please, sir.
Good morning, Your Honor. Michael Beach, BEACH, P 45459 for the plaintiff.
Thank you. Mr. Beach, today is the day and time scheduled for the pretrial in this matter. It was scheduled at 9 o'clock. It's now 9:14 by this court's clock. You and I spoke briefly. You indicated to the court that there was a consent judgment sent to Ms. Taylor that had not yet been returned.
That is correct, Your Honor.
Based on that, Mr. Beach, the court will adjourn this matter adjourn the pretrial over to September the 5th, 2023 at 9:15 a.m. That will be back by Zoom. Should your office receive the signed consent judgment back from Ms. Taylor prior to that date, please send it over to the court's civil department by my file. We'll get it signed and get the matter removed from that September 5th docket.
Sounds great, Your Honor.
Anything else
Thank
this
you.
morning?
No,
Thank
that's
you,
good.
Mr.
I
Beach. Have a
appreciate
good
it.
day.
Thanks, you too.
No worries. This is 230899 GC. Doctors Harris, Burkhill, Wang, and Song versus Nicole Marcel. This matter was scheduled at 9 o'clock. It is now 9:17 by this court's clock. Neither party have appeared this morning. Case will be dismissed without prejudice.
Morning, sir. Can you hear me? With the yellow shirt?
Yes, I can.
What is your name, please?
Don Davely.
What case are you here for?
I have the ticket number or
Sure.
it's X4241-793.
Please.
Sir, is it Davelui? Is that a correct spelling of your last name?
Yeah.
Is it under another name? Is it under Triple Horizontal?
Yeah, that's my company.
Okay, hold on one second, please. You're scheduled to be here tomorrow at 9:30.
I'm sorry.
That's okay.
We'll see you tomorrow, sir. Have a good day.
All right. Thanks, you too.
Thank you.
Bye.
Bye-bye. A citizen. Of course. I love that you have the basket. Thank you so much.
Oh, take,
Oh, that's not a
Let me
good
get
one.
it.
take a couple, maybe you might have to ripen a little bit too. The birds are getting into them heavy.
I know, we have the same problem. I told you we hadn't had apples before, and now this year we're apple rich. They're still small, but we have tons of
They
them.
might, they'll grow some more. I got two
You have two what?
apples. Seriously, on my tree. It's never produced apple before. I got two this year.
I told your dad, we're feast or famine. Last year, we had a total of less than a dozen. This year, it started off with a lot of flowers back in late April, early May, and we're just now about maybe this big. The peach tree, you can't eat them. They're small. They've never gotten big enough for us to eat, but the deer and the rabbits love them. It's the basket that's too much.
Ain't mine.
Thank you, sir.
You're welcome.
Good morning, Mr. Collis.
Good morning, Judge. How are you today?
I'm super. Do you need to speak to Mr. Brown?
Certainly, Your Honor.
Let's get you into a breakout room with him.
Thank you.
Thank you. Mr. Brown, are you seeing requests to go into a breakout room?
I think Mr. Brown's having difficulty getting out of the breakout room. There you are.
This is 225471 GC Forest Health versus Andrew Brown. May I have your appearances, please?
For the record, Your Honor, Stuart Collis on behalf of the plaintiff.
State your name for me, please, sir.
Andrew Brown.
Thank you. Today is the day and time set for the adjourned pretrial in this matter. The parties have had the opportunity to speak. Mr. Collis, how are we proceeding this morning?
Your Honor, it looks like we're going to need a little bit more time. Mr. Brown just got some documents from his insurance company, Humana, that may or may not shed some light on this case. Mr. Brown wasn't sure what to do with them. I instructed him that he has to send me a copy so that I could review them so that we can maybe work through this problem. He obviously also wants to present them to the court. But at this point, Your Honor, I think about another month if we could get those documents to take a look at them, see what they say or don't say. And also, Your Honor, Mr. Brown has not yet signed a HIPAA release, so if we could just have a court order allowing the disbursement of medical records so that the court can see them if we do get to a trial, et cetera, that would be much appreciated.
Mr. Brown, is that an accurate statement of your conversation with Mr. Collis?
Yes, I will bring my Humana report down to the court. And I don't know if I should let you see him. I mean, should I let you see him or not?
Well, there's two things. First, Mr. Collis, I know that we discussed the matter and we put the terms of an order on the record, but I think that when we were here on July 18th, I gave you a date of September 1st, and it should have been August 1st. So although you presented the order that I thought provided your client cover regarding the HIPAA release, I didn't sign it for that reason. I thought it was rejected for you to resubmit it with today's date. But Mr. Brown, yeah, that's what happened. Yes.
I was gonna
Mr.
say,
Brown,
I don't know that I saw that rejection, so I apologize.
well, we're still new to my file, so when I put my note on it and sent it back to the clerks, I'm not sure what they did with it. But
I
Mr.
appreciate
Brown,
that.
if there is a HIPAA release, a release for medical information that Mr. Collis has sent you so that he may access the information, please sign it and get it back to him unless there's some reason why you don't want to
Actually,
sign it.
I never got anything from him.
So we'll do it one of two ways. Mr. Collis, if you want to resubmit your order and just take off the adjourned date, the court
Yeah.
will sign it. We went over this in detail when we were here before. And we can put this matter over either till September the 5th or October the 3rd. Do you have a preference, Mr. Brown?
I would prefer October 3rd, because that way I know I got everything in order.
October 3rd at 9 a.m. I'm sorry, Mr. Collis.
That's fine. You just won't get to see my smiling face because I will be in Turkey. I will have someone else come for me.
Oh, wow.
Hey,
How
it's my
longer
first
will you be in
vacation in 8
Turkey?
years. I'll take it.
How long will you be in Turkey, Mr. Collis?
2 weeks.
Nice. Mr. Brown, we'll adjourn this matter over till October 3rd, 2023, back on Zoom with me at 9 a.m. In the interim, sir, if you're saying that you haven't received the HIPAA release, proposed HIPAA release from Mr. Collis, he'll resend it, or he'll resubmit his order confirming that that you have authorized the release of the documents that we discussed and agreed to back on July the 18th. So we'll adjourn this matter over to October 3rd, 2023, 9 a.m. on Zoom back here with me in courtroom number 1. And Mr. Brown, you asked the question that I had not yet answered about your records. If there's something that you want the court to consider, you're welcome to submit whatever it is that you want to submit. This is a billing dispute.
Yes,
I'm
ma'am.
gathering. So I don't necessarily need to see it. It might become an issue if this matter gets to trial or motion practice. But for right now, it's more important that the information is exchanged between the parties than you presenting anything to the court.
Okay,
Okay?
okay.
Anything else, Mr. Collis?
No, Your Honor. You just have a fabulous day.
You too. Anything else, Mr. Brown?
No, I just never got anything, a HIPAA report or nothing like that to sign or anything, so.
You have time to correct that. You, Mr. Collis, work together between now and October 3rd. I will see you then unless you resolve the case before that time, okay?
Okay.
Have a good day, Mr. Brown.
You have a great one also, Your Honor.
Thank you.
Mhm.
Take care, Mr. Collis.
Thank you, Judge.
This is 231362 GC, City of Southfield versus Denise Hildreth. May I have your appearances, please?
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
State your name for me, please, ma'am.
Denise Hildreth.
Thank you. Today is the day and time set for the first pretrial in this matter. The parties have had the opportunity to speak. Mr. Cox, how are we proceeding this morning?
I think we need to move the case forward with a pretrial order, Your Honor. We didn't get very far with regards to settlement. There are issues with regards to the defendant claiming there was some improper reporting, improper forwarding of the account and so forth.
HIPAA
And
violation.
yeah, I'll let her speak. Yeah, so we need to move it forward.
Thank you. Now, Ms. Hildreth.
What was the question?
There's no question. I asked Mr. Cox how we were proceeding. He was talking, you interrupted. I was going to turn to you for your
No, I'm
response.
okay.
No, ma'am. No. You interrupted him, but I was saying I was going to turn to you for your response or your position this morning. He's asked for a scheduling order. How do you wish to proceed, ma'am?
We can move forward. There was no understanding, as I explained to him. There was no authorization for the Southfield Fire Police Department that they received from me to share my protected health information in regards to them billing me for this ambulance of $530 balance. They did not properly bill Medicaid, excuse me. And they're coming for me for this bill when it could have been satisfied had the City of Southfield Arbor Professional Solutions responded to my debt validation. Everything that I've tried to do to get information pertaining to this debt, pertaining to who was holding the debt, especially as it pertains to my credit report, never validated the debt. And as of today, they have re-aged this debt onto my credit report that is showing that the date of first delinquency, the date of last activity is dated this month, July 2023. I've been going through this for 2 years trying to get information. No one has responded except for these court papers.
Ms. Hildreth, are you looking to receive information from the plaintiff's office?
I was looking to receive information to the debt collector that was listed on my credit report, because that's the only information that I received besides these invoices that do not validate the debt at all.
Mr. Cox, will 30 days discovery be sufficient or do you need longer?
Maybe 45 to 60 days, Your Honor. I anticipate potential pulling of some sort of medical record or run report because my job, I guess, is to try to convince Ms. Hildreth she owes the money. If I can't convince Your Honor, I think along the way, we might need to pull the run report. This is an ambulance bill.
Discovery will commence in this matter immediately for a period of 45 days. Ms. Hildreth, if there's something that you want from the plaintiff's office, submit the request to them in writing. Similarly, if there's things they want from you, they'll submit it to you in writing. That will expire 45 days from today. The court will adjourn the pretrial over to October 3rd, 2023 at 9:15 a.m. We'll be back on Zoom, back here with me in courtroom number 1. The Civil Department will mail you notice of this adjourn date and time. Ms. Hildreth, is there anything else, Mr. Cox?
No, Your Honor.
Anything else, Ms. Hildreth?
No, Your Honor, thank you.
Thank you. You both have a wonderful day.
Thank you, Judge.
Mr. Cates, have you spoken with Ms. Parala?
Not personally, Your Honor, but the crux of the matter is that Ms. Parala has signed a conditional dismissal with LVNV funding that we're just seeking to put on the record and get approval for this morning.
Then let me call the case 231-885 GC LVNV funding versus Cynthia Parala. May I have your appearances, please?
Good morning, Your Honor. Andrew Cates, P78292, standing in for the attorney of record and representing LVNV funding in this matter.
Thank you, ma'am. State your name for the record.
Cynthia Parola.
Thank you. Today is the day and time set for the adjourned pretrial. The parties were last here on July 18th. There was an indication that a conditional dismissal would be submitted. Mr. Cates, the terms of that conditional dismissal.
Thank you, Your Honor. The dismissal is as follows. The defendant agrees to pay the settlement amount of $6,100. Defendant has paid $3,500 toward the settlement amount and shall pay the remaining amount owed in monthly payments of $110 or more. The first payment being due on September 1st, 2023, and all future payments will be due by the first of each month thereafter. If defendant fails to pay in accordance with this agreement or otherwise in a respect to perform defendant's obligations hereunder, plaintiff or its attorney may submit an affidavit of noncompliance setting forth the facts of noncompliance and the balance due and owing, along with proof of service stating defendant has received the information 14 days before said submission. The court, upon receipt of the affidavit, and if no objections are made to the contrary, shall reinstate the case against the defendant and enter judgment against the defendant for the unpaid indebtedness as reflected in the affidavit compliance. In the event the defendant defaults on this agreement, defendant understands and agrees that she will be responsible for the full indebtedness of the outstanding debt. The amount $8,095.13 less payments made plus costs of suit and applicable interest beginning to accrue from the filing day of the complaint. No failure or delay on the part of the plaintiff in exercising a right, power, or privilege under this stipulation shall operate as a waiver thereof, nor shall any single or partial exercise of any right, power, or privilege under this stipulation preclude any other or further exercise thereof or the exercise of any right, power, or privilege. The rights and remedies provided in this stipulation are cumulative and not exclusive of any rights and remedies by law. Defendant shall remit timely payments to Stenger and Stenger at 2618 East Paris Avenue, Southeast, Grand Rapids, Michigan 49546, including a reference number of RS 966466 on the payment.
Ms. Pirelli, is that your agreement with LVMV funding?
Yes, it is. I just have one request. though. Could I possibly get a copy of it for my records?
Has it already been signed
I
and
don't
returned
see
to LVMV funding, Mr. Cates?
Yes, it has been.
Ms. Perella, as soon as the court receives it, the court will sign it. Copies will be mailed to the parties. So you will get a copy of it.
Okay, that would
When
be
we
great.
when we appeared here on July 18th, the court was advised that the conditional dismissal was coming. We still haven't received it. And although, Mr. Cates, you've read the terms into the record, because the court has not received it, what will happen today is I will adjourn this matter over again to September the 5th at 9:30 a.m. But Ms. Perella, if the law firm submits the signed conditional dismissal, you will not need to appear. You will know that we've received it. You'll get a signed copy. That's all we're waiting for them to actually file the document. Other than that, I'm sorry, I cut you off. What were you saying, Ms. Perella?
Oh, I had thought that she said that she was gonna work on that right away the last time. So now we have to wait till September again?
No, ma'am. What I'm saying is we were here in July. The attorney advised that it was coming. And because it was not received by the court, I set a new date, and I will continue to set new dates until a document is filed. Otherwise, the file could possibly fall between the cracks, and we just don't want that to happen. So what I'm saying is, if Mr. Cates has a signed copy of what the parties have agreed to, LVMV funding needs to file it with the court. When it comes here, I'll sign it, and you don't need to come on September the 5th. That's more of a control date to make sure that the document gets filed, resolving the case.
Okay, I understand. Okay, thank you.
Okay, you're welcome. Anything else, Mr. Cates?
Not for plaintiff, Your Honor. Thank you very much.
Thank you. Anything else, Ms. Perella?
No, I think I'm all set. Thank you.
Thank you, ma'am. You have a wonderful day, okay?
Yes, you're as well. Bye-bye.
Thank you. Bye-bye. This is 184742 GC Ford Motor Credit versus Jenkins Easley. May I have your appearances, please?
Good morning, Your Honor. Robin Stradowski on behalf of Ford Motor Credit Company.
Good morning, Your Honor. Gabriel Lacy, P79685 on behalf of Ms. Jenkins.
My apologies for interrupting your conversation. Just wanted to find out where we were with this matter.
Oh, that's
Today's
okay, Your
hearing
Honor.
is the motion, defendant's motion to set aside default judgment and objection to garnishment. Where do we stand this morning?
We did have a extensive conversation about how we were going to proceed in this matter. I believe we've come to a resolution that Ms. Jenkins will pay $200 a month towards this balance. We will agree to set aside the default and enter a dismissal or conditional dismissal. As long as payments are made as agreed, it will remain dismissed and there will be no interest on this. However, if payments were not made as agreed and there was a default, then we would file an affidavit of default and ask the case be reinstated, the judgment be reinstated.
When will the $200 per month payments begin?
We did not discuss an exact date, but I suggested sometime in September. And also the payments that have been garnished so far, if the garnishee is holding on to anything, would be released to the plaintiff to be put towards this balance. If August 10th is okay, then, or I'm sorry, September 10th for a first payment.
Ask if the court will allow Ms. Jenkins to answer that.
Yes, Ms. Jenkins?
That's okay.
Thank you. Ms. Lacy, how long will it take the parties to get the necessary paperwork together as relates to the garnished funds and the set aside of the default judgment and entry of these new payment terms?
I could put the paperwork together today, if that's okay, and email it over to her, and then we could file it with the court. Maybe
That
give
works.
us 3 weeks to get it filed with the court.
What we'll do then is adjourn the pretrial over to September the 5th, 2023 at 9:30 a.m. back here with me in courtroom number 1 on Zoom.
Okay.
If you get the paperwork signed and filed, my file with the court before that date, of course, you don't need to appear. (9:30) on September 5th. Was there anything else, Mr. Drosky?
There's nothing further. We can get that prepared and I will email it over to Ms. Lacy if that works for you, Ms. Lacy.
That works. Do you have my email?
I think it's on your motion.
Yep, it is.
Anything else, Ms. Lacy?
Nothing further, Your Honor.
Thank you. That concludes this matter. Ms. Jenkins, you have a wonderful day, ma'am.
Thank you. You do the same.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. This is 231771 GC, Reliable Auto Finance versus Michael McIntyre. May I have your appearances, please?
Good morning, Your Honor. Jeremy Chisholm, it's P74670. I'm the attorney of record for the plaintiff.
State your name for me, please, sir.
Michael McIntyre.
Thank you. Today's the day and time set for the first pretrial in this matter. The parties have been in the breakout room. Mr. Chisholm, how are we proceeding this morning?
Judge, I think, and I because we literally got pulled out right as we were kind of finalizing things, but I believe we have an agreement in place, Judge, to do a consent judgment with a couple of stipulations. One of them is that no interest will ever accrue on the account. One of them is waiving the any statutory or contractual attorney fee, and the third one is that it would be paid at $100 a month, beginning at a time of Mr. McIntyre's choosing sometime in the next 45 days.
Was that your agreement, sir?
Yes.
Your first $100 payment you'll pay within the first 45 days. What date would that be, sir?
What are we, July, August? That'd be the first week of September.
We'll say like September 10th work for you, Mr. McIntyre?
Yes, that would work.
I'll do that.
September, you said September 10th?
Yes, Your Honor.
And Mr. Chisholm, how long would it take you to get that consent judgment prepared and over to Mr. McIntyre?
Judge, that would be to him. We could mail it out today or tomorrow. We could email it via DocuSign program today.
That being the case, what the court will do is adjourn the pretrial over to September 5th at 9:45 a.m. back here on Zoom, back here in courtroom number 1. But Mr. McIntyre, what'll happen is Mr. Chisholm's office will send you by email the consent judgment, proposed consent judgment with the terms he just placed on the record. And if it's what you wish to agree to, you'll sign it, send it back to their office. They'll sign it, submit it to the court for entry. So long as you get it back to the court before that September 5th date, you will not need to appear on September 5th. That's just more of a control date to make sure that the signed documents get filed with the court.
Okay.
Your Honor,
Okay.
may I inquire as to, or maybe if the court maybe throw us back in a breakout room or something if they don't want to put it live, but inquire as to Mr. McIntyre's email address, because I don't have it here.
You can go back into the breakout room. You were just the last case I had until
Okay, perfect.
10:30,
Thank
and I
you.
just wanted to get movement. I'll put
Okay.
you back into you should be able to rejoin your breakout room, go back to room number 3, Mr. McIntyre. And once you provide Mr. Chisholm with that email address, you may leave the session. The court has noted the terms of the consent judgment along with your next appearance date, but go back into that breakout room, give him, Mr. Chisholm, your email address, and then you're free to go.
Okay, thank you very much.
Thank you, Your Honor.
Thank you. You both have a wonderful day.
You too.
Thanks.
Thank you.
Sir.
Hello,
Hi, what case are you here for?
I have two cases. The first one's set for 10 o'clock, Midland versus Yolanda Fulham. And then my other case,
I don't have anything with that. I don't have anything at 10 o'clock. I have Midland Credit versus Rogers at 10:30.
yeah, I have that one too. This one was adjourned from July 18th. Do you want the case number?
Sure.
187019 GC.
Okay, give me 1 second, please.
Unless we wrote the date wrong.
Okay, hold on.
Oops, sorry.
Yeah, I see that Hullum is at 10 o'clock. I need to call the civil department. Give me 1 second.
Sure, no problem.
Okay. Sir, I just spoke with the civil department and they said that they received a withdrawal from the plaintiff on this case.
Well, I'm in-house attorney for Midland on this case. I don't know what they mean when they say they received the withdrawal from us. There was a hearing on July 18th, and it was adjourned to today for the consumer to have some time to provide some authority on their position at the objection to Garn hearing.
I don't know how to answer your question because this is.
I guess the question is the case still set for 10 o'clock? And then what did you guys receive from us on this file?
Can I have a phone number where somebody can call you?
Yeah, sure. 586-206-0089. And what I'll do is I'll log back in at 10:30 for the 10:30 pre-trial.
Okay, cool. All right. Thank you.
All right. I'll wait for a call. Thanks.
Okay. Thanks. Bye.
All right. Bye.
The host is open.
You're in.
Breakout rooms. Please wait to be assigned. Push OK.
Mhm.
Okay.
You're in.
Okay.
Mhm.
Mr. Rogers, your case is at 10:30, and I know that the counsel is gonna be back on. He was here earlier, but he's gonna be back on at 10:30.
Okay.
Can you hear me?
Yes, ma'am.
Oh, okay, I can hear you now. All right, thank you. Hi, Mr. Perry.
Good morning.
Hi. Did someone from the civil department call you?
Yeah,
Okay.
yeah, there was a little confusion. The defendant withdrew the objection. So
Okay.
no big deal. It's all taken care of. Thank you for helping me resolve that one.
Oh, yeah, sure, you bet. Do you need a breakout room with Mr. Rogers?
Oh, that'd be great. Thank you.
You're welcome. Mr. Rogers, you're going to see an invitation to join a breakout room. If you would just click on that, please.
The breakout, how do I click on? Okay. Mary, for you to join room one. So push join. Okay.
Yes. Mr. Perry, are you ready for the judge?
Yeah, I am. We had a good conversation, very productive. I think we just need some time for discovery so we can exchange some information.
Okay, I'll let her know.
All right, thank you.
You're welcome.
But you still can't see if it's see the bright,
See writing.
but it's still bright on the screen.
It's not turning it, so it's trying to keep.
Oh.
My apologies, Mr. Perry and Mr. Rogers. I was sidetracked by a jury issue.
No problem, Judge.
This is 231454 GC Midland Credit versus Terry Rogers. May I have your appearances, please?
Andrew Perry, P69402 on behalf of plaintiff.
Mr. Rogers, unmute yourself. State your name for me, please, sir. You're muted, sir.
Okay, there you go. Good morning, Your Honor.
Good morning, Mr. Rogers. State your name, sir.
Terry Rogers.
Thank you. Today is the day and time set for the pretrial in this matter. Have you had the opportunity to speak?
Yes, Judge, we had a very productive conversation this morning. We need some time to exchange information. Perhaps a discovery period would be helpful.
How long of a discovery period, Mr. Perry?
90 days.
Let's try 45 to 60.
All right. We just need to get some information from Mr. Rogers, and then we have to forward that to the original creditor to do an investigation on his dispute. But yeah, if we could get 60 days, Judge, that'd be helpful. Thank you.
Mr. Rogers, is that your position as well, that there are documents that need to be exchanged, information that needs to be provided?
I guess, Your Honor, I just explained to him that I showed proof to the court that I paid the debt. Well, I was told by the representative of the company that I paid the debt in full. So I guess they need to find out on their half if that's true, on their behalf.
Thank you. Mr. Rogers, I did review the answer you filed with the court, and then there was some question about that payment or that screenshot of the payment that raised a question.
Okay.
But the court will open discovery. It will commence immediately. Mr. Perry will submit written requests to you for information. You may do the same with him. That discovery period will close on October 2nd. The adjourned pretrial in this matter will be October the 3rd at 9:15 a.m. On your
Judge-
return date, Go ahead, Mr. Perry.
I was gonna say, I thought you were finished talking. Sorry, pardon my interruption. There's one other issue. We didn't receive a copy of Mr. Rogers' answer. If he could please send us a copy, that'd be great, and that would be helpful as well.
You did not receive a copy. I'll make a note in the file to have the civil department mail a copy of the answer to you.
Oh, great, thank you.
What I was starting to say is when you return on October 3rd at 9:15 on Zoom, if the parties have not, if the matter is not resolved, what we'll do is schedule the matter for a motion date and a trial date. So Mr. Rogers, if you receive something from plaintiff's office, please respond to it. Similarly, if there's something you want from Mr. Perry's office, you need to submit that request to them in writing. Is there anything else, Mr. Rogers, this morning?
No, Your Honor.
Anything else, Mr. Perry?
No, Judge.
Thank you both for your patience. You have a wonderful afternoon.
Thank you.
Thanks, Judge. You too.
Thank you. Bye-bye.
Bye.